Good morning. I'm Peter Afrasiabi, an intellectual property attorney with One LLP, and the following MCLE video presentation reflects only my own personal views. Don't hold any other company liable for anything I say that you may not like. So today we're going to talk about why Superman and Steinbeck matter to you. And this is a general presentation for general practitioners and for those of you who may even be trust and estates lawyers. So let's take a look at the first slide. And I want to stand and deliver out of the gate for you about why copyright matters to you. And here's why it matters to you. And this is what we're going to get to in this presentation today. Prior assignments that your clients may have made of their copyrights can be undone and voided at some point in the future by your clients or even by their heirs. Now, if you stop and think about this for a second, it's a pretty profound concept, and it runs counter to the way all sort of general contract law exists. If you go down to the Chevy dealership and you pay them $15,000 and get your Chevy car, you get title to the car, you gave the dealer the money, the transaction is done and it's your Chevy. You would be stunned if at some point in the future Chevrolet came back and took the car back and just said, hey, it's our car, we're going to take it back now. It doesn't make any sense, right? Federal copyright law policy actually allows exactly that type of thing to happen when it comes to copyrights. It's a right then to undo an assignment that your clients may have made, and their heirs can even undo that assignment. And this is an incredibly valuable asset, so to speak, that your clients may have and may not even know they have. And that's why today we're going to talk about this. So let's start with the first slide. I'm going to spend just a few minutes talking about some copyright law principles that are germane to this extended discussion today. First of all, what is copyright? Copyright is the exclusive right to copy, exhibit, distribute, adapt, which is another way of saying create derivative works, perform and display any original work of authorship fixed in a tangible medium of expression. So that is what's referred to often as the bundle of sticks that copyright gets you. Now, these rights vest in the author. The author is by and large the creator of the work. It's sort of the equivalent of a parent-child, right? You are the creator of your children. If you create content, you are the author of that content. The exception, of course, is the work-for-hire doctrine, which will vest ownership in employers for certain kinds of works, and that is outside the scope of what we're talking about today. But for your purposes, you just need to know that this set of exclusive rights on slide 2 attach to original works of authorship. So what does that mean? Well, only a small amount of creativity is required. You may be listening to this MCLE presentation, drawing some doodles on a page, and by the time you're done, you've created an elaborate doodle design. You have a copyright in that doodle design. The courts generally have not wanted to wade into artistic questions about whether your doodle is sufficiently artistic to merit copyright protection or whether it's not artistic enough. Courts like to avoid those questions, and so the result is that the most minimal degree of creativity is all that is required for copyright to attach. Now, copyright attaches to the expression of ideas, not the ideas themselves, and this is very, very important because the theory of relativity, for example, if Einstein had come up with that theory today, his book that he published or his paper that he published that explained that theory, he would have a copyright in it. But the theory itself, the idea of relativity, is not something that he could monopolize through copyright law. So others could write the theory of relativity in their own words and copyright would attach to it. What this also means is that facts are generally not subject to copyright, but copyright can attach to the specific manner in which facts may be organized, for example. On the third slide, we get to the other requirement for those bundle of sticks. It's not enough that you simply come up with an original work of authorship. You also have to fix it in a tangible medium of expression, and that's just a complicated federal copyright code way of saying you have to reduce it to some permanent form. You type on your keyboard and create your Word document, you have a copyright. You pick up the pen, write your letter, you have a copyright. The paintbrush, and do your painting, you've now reduced it to a physical form, you snap a photograph, you've done the same. So, what doesn't count? If you come up with a great poem and hire one of those skywriting companies to fly an airplane and write the poem in the sky, your wonderful poem has not yet been fixed in a tangible medium of expression, you don't have a copyright. You stand outside your loved one's window and serenade him or her with a fantastic love poem you've come up with. It may be the greatest poem of all time. You don't have a copyright yet. Write it down first is the lesson. So, on the fourth slide, what you can see is the types of subject matter that you will find copyright inhering in. Books, music, film, photographs, artwork, software and source code, and even architectural works garner copyright protection. The reality is that copyright law is extraordinarily broad. It's so broad, in fact, that one of my law partners has coined the phrase infringement nation and wrote a book on it, essentially detailing the fact that we as citizens in this country come into copyright and come into contact with copyright issues on a daily basis. As simple as if you go out to a restaurant to have a birthday celebration, you sing happy birthday, you may be violating the copyright in the song Happy Birthday, which Warner Brothers claims to own the copyright to, which you may have heard recently has been subject to a massive amount of litigation to free Happy Birthday to the public domain. But that's why also restaurants historically have not sung Happy Birthday. But maybe you sing Happy Birthday, maybe you infringe a copyright. You snap some photographs at the restaurant, and in the background behind you is an Andy Warhol painting. And you've now taken a photograph of a Warhol painting, you've infringed the copyright because you've made a copy of the painting. While sitting there, you send off an email, and you attach to the email something you found on the internet, a cute celebrity picture. You've probably infringed copyright again. So our day-to-day activities bring us into contact with copyright constantly. So when does copyright exist? And this is very, very important for our discussion, and it gets a little complicated. Copyright exists for works that were created before January the 1st, 1978, and that date, 1178, is a very important date that I'll keep referring to, so just keep in mind 1178. For works created before 1178, copyright existed at the time of publication of the work. And at various times before 1178, there were formality requirements about putting the little C and the date and the name. Those no longer exist, but for general purposes, it would exist at the moment of publication. Now, as of January 1st, 78, it exists at the time of creation. So you're still doodling, let's say, listening to me here talk about copyright, and your work that you are creating right now, right this second, you have a copyright in because it now exists at the time of creation. So how long will the copyright last? Again, the length of how long a copyright lasts varies depending upon when it was created. 1178, again, is the bright line date as you see on the slide here. For works created after 1178, copyright lasts generally for the life of the author plus 70 years. So if you're doodling today, it'll last until you die, and then for 70 more years. For works created before 1178 and published before 1178, copyright has varying lengths of duration. Originally, it lasted for 56 years, and there were two 28-year terms, which is why you see there it says 28 plus 28. Then in the mid-1970s, because many, many works were about to hit the public domain, and Congress was revisiting the copyright laws, part of the amendments that went into effect on 1178 also altered the length of the life of those copyrights that were already in existence. And so they added 19 years. So at that point, by the mid-70s, works created before 1178 could last for 75 years. Now, in the mid-90s, if you fast forward a little bit, you had further amendments to the Copyright Code, further extending the life of copyright for those works created before 1178. Another 20 years was given, and this was what's known as the Mickey Mouse Law, and that's not meant in the pejorative sense, it's meant in the literal sense. It was Disney, by and large, that was lobbying Congress, along, of course, with other content owners, to extend the term of copyright because Mickey Mouse was about to fall into the public domain. And so they got a reprieve from Congress, the Supreme Court held it constitutional, and so copyright now lasts for 95 years for those works created before 1178. So now let's talk about what is this right to terminate that assignment. And so as you can see here, for works created before 1178, this right to terminate is a right that allows you to void a prior assignment or grant of copyright unless that grant was made by a will, and get back the copyright for the remainder of the life that that copyright may have. And so what that means is you can terminate that grant and get back those last 39 years the 19 plus the 20 years in the 2 amendments I just spoke about. Or if you miss the first 19 years, you can still terminate at around the 75th year and get back the last 20 years. So the question then is, wow, this is great. I can get back a copyright. Maybe there's a lot of value there. When can I do it? Well, you do it in a 5-year window of time between the 56th and the 61st year. Or between the 75th and 80th year if you're now looking to get back that last 20-year window. So on this slide, you can see the actual quote from the U.S. Copyright Act. This is the 1909 Copyright Act that governs works that were published, created and published before 1178. And so the 1909 Act, of course, is still very, very relevant to us today because those works created under its terms are still in existence and subject to these issues we're talking about. So this is what the 1909 Act says for those works. Quote, in the case of any copyright subsisting in either its first or renewal term on 1/1/1978, January 1st, 1978, other than a copyright in a work made for hire, the exclusive or non-exclusive grant of a transfer or license of the renewal copyright or any right under it, executed before January 1, 1978, by any of the persons designated by subsection A1, capital C, of this section, otherwise than by will, is subject to termination under the following conditions. And then it proceeds to outline the conditions that we're talking about here. On this next slide, you can see we're now going to talk about the effect of termination. In other words, what do you get back? What does it mean? How does it benefit you? How does it benefit others? Well, all the rights that were terminated revert to the owners of the termination right on the effective date of termination. And so what that means is, if the termination is effected properly, those federally defined folks now own this copyright, this asset, and they can then enter new agreements with it. They can enter a new agreement with the old assignee, the old publisher. They can go enter with new publishers. They can enter whatever agreements they want with whoever they want, or not enter agreements. They own the copyright now. In fact, if they want, they could warehouse it and just not create any new works because they don't want to see the copyright exploited and monetized for whatever reason. We also see here that binding agreements with a transferee whose agreement is being terminated can be entered into after notice is sent. So once you've given notice, you don't actually have to formally, ultimately conclude the termination. If you've given notice and then you start a negotiation and enter an agreement, that will itself be binding and it won't be held to be invalid. Derivative works that the original transferee had created can continue to be exploited by that transferee. So we're going to talk about Superman in a little while, and what that means is that DC Comics and Warner Brothers own the copyright to Superman for the majority of the 20th century, or all of the 20th century. And they created a bunch of TV shows and movies and comic books and whatnot. If the heirs to Superman were able to effectively terminate and get back the rights to Superman, the heirs would not get the rights to those derivative works, those movies and TV shows and comic books and whatnot that were created in the 20th century when they didn't own the rights. The copyright owner to that would still be Warner Brothers, and they could continue to, re-release the same movie, sell it to Netflix, license it to HBO, whoever. The difference being, Warner Brothers could not create another TV show. They couldn't go and create one more episode of the Lois and Clark series, for example, because that would be a derivative work they no longer had the right to do. But they could continue to issue reruns on the works they had already created. The other thing that's relevant here is that then foreign works are exempted from this. So all foreign exploitation that had occurred can continue. New works, though, to be created, if a new TV show was to be made, let's continue on with the Superman example since we're going to talk about that in a little while. New Superman TV shows, new Superman movies, if the heirs are able to terminate, they then own the right to create those new movies. And those movies and that content then would be copyrighted content that they're able to exploit. 1976 Act works, and so this is the code as it addresses works created after 1178 and dealing with this right to undo an assignment. And the 1976 Copyright Act, and by the way, we keep talking about the 1976 Copyright Act, but I keep saying 1178, and you're asking why 1976, why 1978, what's going on? The reason is the following. The Copyright Act was passed in 1976, but it was effective January 1st, 1978. So the operative date that's very important is 1178, but the act itself is known as the 1976 Act. And this is what it says, quote, "In the case of any work other than a work made for hire, the exclusive or non-exclusive grant of a transfer or license of copyright or of any right under a copyright executed by the author on or after January 1st, 1978, otherwise than by will, is subject to termination under the following conditions." And it proceeds to list all those different conditions. Now, one very important point you'll note, the difference between, a couple slides back I quoted the 1909 Act, now I've quoted the 1976 Act. There's one difference in the verbiage that's very, very important, and that will come to light in a little while when I talk about the Steinbeck case and why the Steinbeck case is very important to you and how it affects this analysis. And so the difference in language is, as you will note, look back at this slide, it says executed by an author. So it's dealing with those assignments that were done by authors after January 1st, 78. If you go back a few slides to the 1909 Act quote, there isn't that limitation in that statute. It doesn't say executed by an author. It simply says an executed agreement before January 1st, 78. So it could have been author agreement, but it could also be an agreement executed by the author's heirs before January 1st, 1978. So that is a distinction that's subtle but very, very important, and it'll play itself out when we talk about Steinbeck in a little while. What about for works created after 1178? So now we can think about works that that we've all witnessed being created certainly in the last 20, 25 years of our lives in pop culture. For example, Madonna's music. Madonna created her content in the 1980s. She may have assigned it in the beginning to a record label or a publisher. That assignment, Madonna can undo. When can she undo it? She can undo that assignment 35 years after she made the assignment. So, if you just stop and think about that, massive bubble of content created starting especially in the 1980s with the proliferation of computers and the new media age. All that content, pop media content, which now is being repackaged and reformulated and finding new value in ringtones and websites and whatnot, can all be potentially undone and taken back by those people who originally granted assignments of the copyright content. When can it be done? For these works, it's a little complicated. For these works, the grant can be undone between 2 and 10 years before the 35th year of assignment. So, let's just take the Madonna example. Madonna in 1980, let's say, assigned her first sets of songs. 35 years later is 2015. She can terminate that assignment and get back her copyrights in the year, starting in the years 2013 to 2005, 2 to 10 years before that 35th year. So this is part of the reason. You may remember the famous quip made by Paul McCartney when Michael Jackson was buying a lot of the Beatles' old catalog. And Michael Jackson was spending a fortune, as you remember. And there was a famous quip in the press by Paul McCartney who said he didn't care and it didn't matter because he would be getting it back one day anyway. What he was referring to is exactly this set of laws. So the next question is, who may terminate and how? And this is particularly important for you and your potential practice when you're issue spotting questions for your clients. The author may terminate that assignment that was made, but even the author's heirs, the widow, the children, even the grandchildren, can terminate an assignment that was made by their parents or grandparents, even if you go down that far. This is a remarkable concept, and this is why this counterintuitive federal policy is so important, but not known and not thought about, precisely because general contract principles allow free voluntary exchanges to be made. Those exchanges are made. End of story. Not here. So, this is a federally defined class, as you see on the slide now. It's the author. If the author has passed away, the heirs can do it, and that would be the children. And these can be undone even if the author passed away in his lifetime and specifically wanted his copyrighted works to go, for example, to some particular charity, let's say. And there's a famous case involving the famed American playwright William Saroyan, who wanted his plays that he had created to go to a charity that he had also established, and he wanted that charity that was in it was a foundation that was being run by others at that point, but he wanted them to have the rights to his plays so that they could continue to create derivative works, adapt the plays, publicly perform the plays, and whatnot. So he left the plays to that charity in his trust. Well, he passed away, state intestate principles took over, the process ran its course, and through proper state channels, the trust was held valid, of course, and the asset moved to the charity, and the charity was unable to exploit it. But 56 years later, after the work was originally created, William Saroyan's children came along and said, we want to take that back. We don't want the charity to have it. The charity said, are you kidding me? We got it under basic state principles. It's ours, of course. Children said, no, it's not. We have the right to void that grant because that was a grant that went through a trust. And the only exception to all of this is if it was made through a will. And the federal court said, yeah, you didn't put it in a will. Children get back the plays. So in order now to effect this termination, you need a majority interest. What that means is if there's a widow alive, the widow has 100% of the right, the widow can do it. If there's children alive, the right's going to be divided among the children, and you need to get a majority of them on board to do it. So the widow may have 50%, you may have two kids who have 50%, you need to get agreement, otherwise you can't even effect the termination right. And if you don't effect it in the window, you lose it, and you have to wait, if you're lucky, for that last 20 years, if it's an older work. But if you miss it on the 35th year for works created in the more modern age, you've forever lost the right to terminate. Now, if there's no widow or children or grandchildren, the federal code also defines who gets it. It's the executor, the administrator, or a trustee owns that entire right to effect a termination. So you can see on the next slide, it's important to recognize that U.S. copyright law defines who the heirs are, and it defines the basis on which they may take these assets. And these are federally defined provisions, which I found over the years. I've spoken to many different groups around the country. These federal terms differ with some of the states' definitions of heirs and how states define assets passing by state intestacy principles absent a will. But here, federal law will trump. So the federal law is very important to understand and follow. It defines a widow as the author's surviving spouse under the law of the domicile at the time of death. So there we borrow state law. It defines children, though, not in such a manner. It defines children as a person's immediate offspring, whether legitimate or not, and any children legally adopted by that person. That may or may not be consistent with all of our jurisdictions across the country. It also does not define grandchildren. And so although the issue has not been litigated, if a question arises about what the definition of a grandchild is, you probably would argue and be able to convince the court that you should borrow the state in which the author was domiciled at the time of passing. Now, one question that comes up a lot is, what if you have a domestic partnership law in the state? Under federal law, you often look to the state's definition, as you see above. And so in California, at least, California has been very, very clear under the Unruh Act, and this is the case Kobke versus Bernardo Heights Country Club. It's 36 Cal 4th, 824 at page 831, the 2005 Supreme Court case, that registered domestic partners are the equivalent of spouses for purposes at least of state law. And so under federal law, the same principles would probably apply. Now, one caveat that's very important to recognize. This right to terminate that we talk about, it's not an asset in and of itself. So, you're creating your doodle today. And let's say at the end of this program, you call me up and say, hey, Peter, I created a great doodle. Do you want to buy it? And I say, yeah, I want to buy your doodle, and I want the copyright to your doodle. So I give you $5, and you give me the copyright to that doodle. 35 years from now, of course, you can undo that. But that right to undo it in 35 years is not another asset of yours that you can sell, pledge, or give away. It's a contingent expectancy type interest, the federal decisions have said, that only comes into existence at the time that that window to terminate exists. So you don't get to do anything with that right to 35 years from now come back to me and say, hey, I want my doodle back. You have to wait 35 years, and if you're alive then, you'll be in the class of people who can terminate. If you're not, there'll be a class of people that the federal code has defined who can terminate. But this is an important point to keep in mind. So, how do you terminate? How do you have a client talking to you who says, oh my goodness, my grandpa created this incredible movie. Everyone's watching it still. He assigned the copyright. I want to get it back. How do I get it back? Well, the famous quote from a famous copyright commentator is, as you see, it's a feat accomplished against all odds. And indeed it is. The reality is that it is very hard, and it's a procedural morass. This is one area where you need copyright expertise to navigate this field, because it truly is a Byzantine set of procedures that exist in the U.S. Regulations and the Copyright Office Code in terms of who has to be given notice, when you give notice, how you give notice to all interested stakeholders. Very, very complicated, but it can be done. So let's say you navigate it. What do you get back? And this is starting to get us to our discussion today about Superman and Steinbeck and why, in your practice, Superman and Steinbeck actually matter more than just being great media you consume. It matters to your practice of law. What does it get back? All of the rights that were assigned originally revert back to the original grantor, except for those derivative works that were created while the grantee had the work. So, for example, you assigned me, as you remember in our hypothetical, your doodle, the copyright to your doodle. I then spend the next 35 years creating derivative works from that doodle, and I add some color to it, and I turn it into an online digital painting, and I sell it. And I make a bunch of money selling this sort of painting, now let's say, that has been modified a little bit, color added and whatnot. That is a derivative work. That I can continue to exploit even after you terminate the copyright, because that derivative work was created by me during the period I own the copyright. But you get back the copyright. So further derivative works and further exploitation of the original copyright now solely belongs to you. That's the general rule. So your head is spinning at this point. Why, you're asking? Why is this federal policy about copyright so inconsistent with our general state principles of contract law? And here it is, as you see. Congress recognized and has long adopted and believed that there's staggering unequal bargaining power between our authors, the class of people in our society who create this great content that we consume, that moves us, inspires us, makes us laugh. The unequal bargaining power is reflected in the fact that the authors at the time of creation don't know if their creations will have much value, and they are negotiating with publishers who have a lot more economic power and leverage. And this recognition of unequal bargaining power, Congress has recognized, causes authors to often make assignments of their copyrights that may not be financially rewarding and may not truly reflect the real value of the work they assigned. That's why Congress has said, you have the right to come back later and revisit that assignment. So, take the most simple example of the assignment. You sold me your doodle for $1 or $5, I think we said in our hypothetical. $5 is not a lot. And it turns out I turned that doodle into a $1 billion enterprise because it's just the greatest single doodle art anyone has ever seen. And you, lo and behold, are kind of bummed because I'm making billions of dollars, you only got $5. Well, that's why you, 35 years later, get to revisit that assignment and say, you know what? Let's renegotiate, and we're going to have a different split of money. And we will have a different split of money, of course, if I'm forced to renegotiate as the publisher and the copyright owner. So, again, this is a little antithetical to the basic principles that you're used to. The Chevy example in the beginning is one. I mean, the basic principle of American jurisprudence across the whole country is free contract rights. We bargain, we negotiate. If there's no duress or unconscionability, and you have an arm's length exchange between people, consideration is given. It's a fair contract. You don't get to undo it, and it doesn't seem to make sense that you even get to undo it. That's why your head is spinning, because U.S. copyright law has said the opposite. And in fact, U.S. copyright law has said more than the opposite. It's not just that you can undo it, you don't even have to give back the money. So, again, in my example, I gave you $5 and I got the doodle. You can come take the copyright back. You don't even have to give me the $5 back. And so perhaps you could think of it in tribute to the fact that we're about to start talking about Superman. It's better than even rescission. It's a super rescission, so to speak. So on the next slide, you can see the quote of the actual policy, and I'll read it because it's a very important policy to keep in mind because it animates the discussion we're about to have regarding Superman in the works of Steinbeck. The principal purpose of the amendments, and the amendments it's referring to are the ones that deal with this right to terminate and get back the prior assignment, was to provide added benefits to authors. The concept of a termination right itself was obviously intended to make the rewards for the creativity of authors more substantial. More particularly, the termination right was expressly intended to relieve authors of the consequences of ill-advised and unremunerative grants that had been made before the author had a fair opportunity to appreciate the true value of his work product. The general purpose is plainly defined in the legislative history and indeed is fairly inferable from the text. So, this policy really does sort of adopt a paternalistic type approach to our authors. And we've sort of concluded, we, the body politic through Congress, that is, that authors are a special class, that federal law is going to define differently when it comes to traditional contract principles in terms of how they may negotiate their copyrights. And this paternalism takes shape and form through this policy that allows them to undo these assignments. And so society, part of what's going on here is we've said society benefits greatly by the creation of new works. We're all moved to experience great emotion through incredible works. And the authors who are doing it are providing an incredible benefit to society. And it's a benefit that may or may not be borne out by the work they're creating, as they're often slaving away in isolation and solitude for no money. And so we want to encourage and incent that and make sure that they receive a fair share of the bargain. And so this right to renegotiate and get back the copyright is the reason this has existed in the law for many, many years, decades, centuries, in fact. So this policy is so strong, at least as written by Congress, and this is where it gets interesting, that, as you see on this next slide, any lifetime agreement to the contrary is void. This is written in the U.S. Code. What this means is that you cannot enter an agreement whereby you agree that you will not exercise your right. It's simply a void agreement if you enter an agreement. So let's go back to the doodle hypothetical. I've got the copyright to your doodle. I gave you the $5, but I also say, hey, you know what? I think this doodle is going to be worth a lot. I don't want you 35 years from now to come back and tell me that you want to terminate. Sign an agreement today agreeing that you'll never do it. You can sign that agreement, but it's void as a matter of federal law. The only way to make sure, again, is if you want to make sure you, the creator, you want to make sure no one can ever undo it, is you keep your copyrights and you pass them by will to whatever organization, and then you're okay. Now, for those of you who are sort of the law and economics, utilitarianism type folks who are unhappy with what you're hearing right now, stay tuned, because now I'm about to start talking about Superman. And what you're going to find is your concerns about this doesn't really add up under sort of my general jurisprudential thinking. You find that those same concerns and feelings you're having are also experienced by our federal judiciary, who are, as we shall start exploring, finding ways to conclude that agreements to the contrary are not really to the contrary. So this now brings us to 1938 and the Superman and Steinbeck cases that I'm going to talk about with you to explore these principles and how valuable this right to terminate is. Interestingly, both of these stories will start in 1938, so clearly something was going on in that year, as we'll see. So let's start with the Superman case. It's 1938, and there's two high school friends, Siegel and Schuster. Siegel's the artist, Schuster's a writer. And they come up with this idea, and they're in high school, they're in journalism, doing journalism in high school newspaper, and they come up with an idea for Superman, and this creation of theirs, who we're in the Great Depression, he's fighting evil, he's supporting the average person, and they have this idea, they love it, it's great, and they're trying it in different formats, trying to find someone to publish it. They don't have much success. In fact, at one point, Siegel's so unhappy with the process, he throws the Superman material they've created into the fire. Schuster dives in, saves it from the fire. Lucky for all of us. They then go around, and eventually they find DC Comics, and DC Comics says, you know what, I like the content you've created, we'll buy it, and tells the young guys, we'll give you $130. They say, okay. They take the $130, they assign the copyright to Superman to DC Comics. DC Comics is rolling in money almost instantly, even in those days. And Superman's a great success. So, In that time period, in 1938, if they had had lawyers representing them, and maybe they did, maybe they don't, I don't even know sitting here. But what they would have known is that 28 years later, if this assignment they made turned out to have been an assignment of copyright content that's really valuable, they could get it back. So they knew, 1966, if this Superman thing turns out to be a big deal, we'll get it back. And so they sat there thinking, no doubt, holy cow, it's making countless amounts of money and TV shows, whatnot. Great, 1966, we're going to renegotiate, and this time we're going to get a little bit more than 130 bucks. But something happened in the interim. 1940s, a big case goes to the US Supreme Court. It's a case called Fred Fisher. This is a case that pitted, it comes out of the music industry, and it pitted creators of musical compositions and musical works against the publishing houses. And the case that went up to the US Supreme Court raised the question of whether an agreement to the contrary was really an agreement to the contrary. And what the US Supreme Court held was that if someone assigned all right, title, and interest to the copyright, that also included the right to terminate. Even though the law said the right to terminate can't be voided, it really did. And the US Supreme Court agreed with the powerful publishing interests, and hence, in the mid-1940s, agreements of all right, title, and interest to copyright were held to void your right to even renegotiate. So the mid-40s rolls around, and now Siegel and Schuster have learned from the Fred Fisher case that they have a big problem. The 60s roll around, they try to litigate the issue, and because of the Fred Fisher case, they lose. By the time you get to the 1970s, Warner Brothers now owns the copyright to Superman, and you have now what is a billion-dollar franchise, Christopher Reeve movies and all that. And in fact, sadly at the time, Siegel and Schuster are now much older in life, obviously, and they were living in really destitute, difficult conditions. And in fact, there was such an outcry in New York Times articles that Warner Brothers, it gave them a sort of a lifetime pension of sorts because of the publicity it was brought to bear on how the creators of Superman had nothing and the owners of Superman were minting money. So, at that time, they probably figured, well, we're out of luck. But luck struck them. 1970s roll around, Congress is amending the copyright laws, as you remember, 1178, the new date for copyright, and the content owners said, we want to make sure copyright lasts longer than this 56-year period. So an extra 19 years were tacked on. That meant, for Siegel and Schuster, they now at last, 56 years after the 1938 assignment, could go knocking on the door of Warner Brothers, try to terminate the assignment and get back the rights to Superman. And so that 56-year period started around 1994. And so the mid-90s roll around, and as you see, their window of time on the slide was 1994 to 1999. Sadly, Mr. Siegel died in 1996, but his widow and daughter did trigger a termination. And so they sent a letter to Warner Brothers and the other rights holders saying, we're terminating, we want back the rights to Superman. This, of course, spawned a massive amount of litigation. Now, part of what happens, and this is why it's a Byzantine process, and as the copyright commentator said, it's a feat accomplished against all odds, is that when you terminate, you need to specify a date of termination. And so the lawyers for Siegel's heirs said, okay, well, the original copyright assignment was made April 16th, 1938. And so they said, we are specifying the termination date exactly 61 years later, that 61st year in the window, which would be April the 16th, 1999. Now, meanwhile, the parties were obviously also negotiating towards a resolution in this melee of litigation that was now unfolding. But what's very important is the following, and this is where the code gets complicated, and this is where it gets really interesting. You go back 61 years to April the 16th, 1938. Everything that was in existence after that date was the copyright that they were terminating, getting back. But if anything of Superman had been published before that date, they would not be terminating that. And Warner Brothers, as the successor to DC Comics, would still own the copyright to that. So why was April 16th, 1938 picked? Well, that was the date of the first publication of the first Superman comic. And so they fairly felt nothing else had been published before April 16th, 1938. We're getting back everything. Well, litigation, discovery, largest law firms in the world, and pouring through ancient documents, engaging in sort of the archaeology that we in litigation engage in on old documents. And lo and behold, what did Warner Brothers discover? You see on the next slide. They found some evidence that showed there had been a publication of some of the Superman elements 1 week before April the 16th, 1938. It was on April the 10th, 1938, and you see it here in this comic. It was an announcement page for the Superman comic that was to be issued the following week on April the 16th. And you see in the announcement, a week before the specified termination date, a picture of Superman holding up a car. So, and here on the next slide, you can see a comparison between the announcement and then the actual comic as it was published. The actual comic is the one on the right that's in color and larger. You can see it more. The original announcement, unfortunately, there's not a great copy of it, but you can see it there on the left, and it's a black and white version. So, any published Superman content before that, the one on the left, would mean Warner Brothers is okay and they can continue to exploit that content that they had already published and was subject to statutory copyright at the time. So, the question in the litigation then, and this was litigation pending in the Central District of California, here where I litigate. It was before our then Judge Larson. The big battle lines were drawn over, all right, Warner Brothers still owns something. What do they own? And Judge Larson concluded, well, that slide on the left shows a guy wearing leotards in black and white holding up a car. He doesn't have the recognizable S on the back of his cape. There's not even a mention of Superman. There's no Lois Lane. There's no Krypton, no Kryptonite, none of the other familiar elements. And so what Judge Larson concluded in the Central District was, yeah, you can continue to exploit a guy in black and white in leotards with a cape. And that's about it. This, of course, is a devastating blow to Warner Brothers in the litigation and a staggering victory now to Jerome Siegel's widow and his daughter. So, as you see, the district court said, as of April 16th, 1999, the termination date, the heirs get back the rights to Superman. This, of course, also is part of the reason why there were many years there where we were not seeing lots of new Superman movies, because of the uncertainty. But, as in all American legal stories, Warner Brothers appealed. And so, what happened on appeal in the Ninth Circuit is they trot on up, they file their appellate briefs, and there's a massive amount of briefing. And one of the arguments that Warner Brothers made was, hold on, we'd been negotiating towards a resolution many years earlier. And in fact, we reached a resolution. And they argued that we had a contractual agreement that settled everything. And it eliminated your right to now continue to exploit this termination right because you, the widow and the heir, settled with us. And this is a quote from the record. This is to confirm our telephone conversation of October 19th, 2001. The Siegel family, through Joanne Siegel and Laura Siegel Larson, the majority owners of the terminated copyright interests, has accepted DC Comics' offer of October 16th, 2001 in respect of the Superman and Spectre properties. DC now sends along, through Warner Brothers, a formal letter agreement, had some new terms in it. The new terms were rejected. No clients ever signed the agreement. And so the heirs' position was, we never entered an agreement. We were close, but no deal. The Ninth Circuit, however, said, no, you had a deal. You had a contractual deal, end of story. And so they then reversed, holding through copyright law, but utilizing California state contract principles, the paramount importance of the nature of this contract and this contractual relationship. So here you have an example of contract law principles that we all sort of understand and expect, trumping the nature of the federal policy to some extent and being enforced and used. And so the case then goes back to the district court to enforce the terms of that deal. Now, by no means was that deal horrendous for the heirs. The heirs were getting a lot of money, obviously, given the negotiation, but it wasn't the same as if they had been able to retain the entirety of the rights to Superman to then sit down and exploit it themselves, create their own movies, or maybe renegotiate again. Went back down. There was more litigation in the Central District, now before a new district judge, since Judge Larson had stepped off the bench. The new district judge says, no, this is a bona fide agreement. That's what the Ninth Circuit said. All the defenses and arguments made to get around the agreement, I reject. And interestingly enough, it went back up to the Ninth Circuit, and just in October, November of this year, 2015, it was argued again to a new panel in the Ninth Circuit, and we're awaiting decision. So stay tuned. There may be another video from me. It would be Superman Returns next time to see if anything changes. So The next case we come to is the Steinbeck case. And again, this case also starts in 1938 when Steinbeck assigned his works. And you've got his famed works, of course. Now, Steinbeck remarries. He dies in 1968, and he leaves his estate to his second wife. He had been married before, and he had kids from his first wife, but he left his estate to his second wife. 1994 rolls around. Again, 1994, a big year for people who did stuff in 1938. It's the termination window. So his two children from his original marriage and the widow, between them own 100%. The widow owns 50%, the kids own 50%. Kids say, let's terminate this deal. The deal, by the way, was with Penguin, the entity that's to this day selling John Steinbeck's works. Widow says, no, I'm good with the deal. I'm not going to terminate. And the kids really want to terminate, the kids from the prior marriage, and so you get all of that in there, of course. And she says no. So the kids are out of luck. And at that point in time, 1994, they figured, yikes, that was our chance to get back Dad's works. We can't do it. We're never going to get anything. And the widow, at the same time, entered a contract with Penguin. And she wrote an agreement out with Penguin, with Penguin's lawyers. And everyone here is represented out in New York by sophisticated counsel, of course. And she, as the successor to Steinbeck under his original contract with Penguin, entered an agreement that effectively rescinded the original 1938 copyright assignment and restated new terms to Penguin, with new royalty splits going to the widow and, of course, for her children. Nothing for the kids, the original kids, right? That was the contract she entered. The kids at this point, of course, figured, well, copyright lasts for 75 years because we had the 56 years plus the 19, remember, we're out of luck. But lo and behold, remember the Mickey Mouse law? Late 90s roll around, another 20 years is given. So that the heirs, then the original children of John Steinbeck, then figured, okay, at least we'll be able to get back the last 20 years, from the 75th to the 95th year. The years roll on, the widow passes away. So now the kids say, at last, we own 100% of the termination right between us as the original children. They go to Penguin and say, we're terminating, and we want to take back copyright to Dad's works. Penguin says, no. Massive litigation unfolds. And Penguin's position is, you have nothing to terminate. The 1994 agreement rescinded the original agreement, and so you're out of luck. There is no 1938 agreement even left to terminate. The kids raced into court, and of course in the district court argued, that's an agreement to the contrary. And the whole principle and premise of the federal code is that agreements to the contrary, agreements designed to subvert this termination right that exists in this federally defined class of people, can't be subverted by creative contract lawyering. District court says, yeah, you're right, it can't be, and says it's an agreement to the contrary. But as with all of our stories, there's an appeal, and it goes up to the Second Circuit, and the Second Circuit then gets the case, and the Second Circuit says, no, it's not an agreement to the contrary. It's a legitimate agreement entered by the successor who had every right to sit down, enter an agreement, and rescind. That's what she did. So the only agreement on the table anymore, as of now, the early 2000s, is the 1994 agreement that was entered by the widow. And by a quirk of the copyright laws, when you look at agreements entered after 1178, the only agreements assigning copyrights that can be terminated are ones that were made by the author. And she was the author's successor, and the successor didn't count, the Second Circuit said. And so it employed this logic to tell John Steinbeck's original children, you're out of luck again. And they were out of luck. Tried to go to the U.S. Supreme Court. The Supreme Court didn't take it. So here you have another example of the federal courts interpreting and applying this federal policy as written by Congress, but concluding that that was not an agreement to the contrary, when I think the fair reading, at least in my opinion, and the opinion of many, many copyright experts and commentators, is that that really was an agreement to the contrary designed to subvert the principles of the Copyright Act that's designed to protect the defined class of people who would have been John Steinbeck's kids. But they were out of luck. So I have one more piece of intellectual property to talk about with you, and that's Captain America. How can we talk about Superman and Steinbeck and not also talk about Captain America? Because Captain America offers an interesting case that pivots. Captain America, created in 1940 by a guy named Simon, he sells it to the publisher entity that he was working with at the time. 28 years later, 1968, He renegotiates with them because he could, and he settles on a new deal with the publisher. He gets more money, they get certain rights and whatnot. Part of that deal, though, in 1968 was the publisher made him agree that back in 1940, when you created the work, it was a work for hire, so we've always owned it. Now, he in 1968 signed off on that agreement. He was collecting his money, presumably, so he was happy with it, and asserted that, yeah, okay, that's fine, it was a work for hire, whatever you say. So, that's what he did in 1968. And he figured, end of story, right? You know, you only get this thing for 56 years anyway, so it's the last 28 years. But, again, as we know, Congress extended the life of copyright, so all of a sudden he was able to come back to the table and say, hold on, I now want the last 19 and then 20 more, the last 39 years, 56 years after 1940. Litigation unfolds again, and this is again in the Second Circuit, and the district court there says, well, this is a pretty clear agreement. You agreed it was a work for hire, it was never yours to begin with, so there's nothing to even terminate. Second Circuit concludes the opposite, and this time the Second Circuit says, no, that is an agreement to the contrary. And so right now your head is spinning, you know. Steinbeck's was not an agreement to the contrary, this one is. How do we harmonize and explain this? What animated the Second Circuit here is the fact that, one, it was litigation by the original author, and that is certainly part of the calculus that's at work here and distinguishes this case from Steinbeck and Superman. The original creator was the one litigating. The other thing that clearly troubled the court was the fact that someone entered an agreement 28 years later that redefined the nature of the relationship 28 years earlier. And to some extent what the court was saying is whether something was a work for hire in 1940 is a function of the facts and circumstances on the ground at the time. And you don't get to rewrite history with creative lawyerings and redefine something as being an animal that it wasn't at the time. And they just didn't like that. And so that's part of the rationale and explanation for this. So we've now explored these famous literary, creations and works in our culture, and so now you understand why these works are not just media for you to consume that's really interesting, but they're actually important to your practice. And so what are the important points? And this slide is designed to talk about the important points that I want you to take from this discussion today. One of the first ones is the assumptions that you as a general practitioner in your jurisdiction where you live and where you work, the assumptions that you make about state intestacy and probate principles that govern may or may not collide with the Federal Copyright Act. And those assumptions that you make, for example, the Soroyan case I talked about, where the state law was complied with, it went into a trust lawfully, properly, correctly, those principles collide with federal law, which dictates a very, very different result. The other point to take from, especially from the case discussion we just had about these fascinating cases, is that as a society, we've written a massive concern for protecting authors and their heirs from these unremunerative transfers that they may have made and no agreements to the contrary. And this is a massively important policy to allow people to sit at the table and renegotiate with a new arm's length transaction, right? That policy, however, is certainly not guaranteed, and courts struggle with that policy and enforce agreements that appear to be invalid agreements at times because courts are finding the tension, the same tension that I probably alluded to in the beginning of this that you are probably feeling about how this federal principle is inconsistent with our general principles of state contract law. That tension gives you room to litigate, and it gives you room to argue and make the arguments and do what we as lawyers do, and that's where there can be value in negotiating and arguing whichever side of the table you're on these types of transactions. So, two big issues. Who are you looking at? What kinds of clients are you looking at that this could happen? Number one, clients who may come to you who own copyrights currently, who owned them before, who have assigned them, people who've created content, and they are concerned about making sure that their copyrights, either ones they've assigned or ones they still own, go to certain people in certain ways. And you need to know that the general principles that you bring to bear on those types of problems that are dictated by your state law are not the sum total of the story. You have to look at federal law to have a clear answer on this. The second are clients who have in fact don't currently own but have assigned away works, and maybe even the heirs. And this is the type of thing that doesn't get caught often. I mean, either from the person who assigned it or especially from the heirs. Primarily because You may represent someone who 50 years ago created something and assigned it away. You don't think to ask him about that. He or she may not think to even mention it to you because, just like the Chevy example, they got some money, they assigned it away. They can't imagine that they have the right to take it back. But now you know they do. And so you want to be asking the right questions of the right people to get to the bottom of whether this asset exists out there, which is effectively on their personal balance sheets, that can be negotiated for and secured back. So one scenario that you deal with this in the sort of the scenario of clients trying to marshal their assets. This is the people who created copyrighted works. They've got them. They have all their works, and they're getting on in life, and they want to make sure that their works are exploited in future years in exactly the manner they want it. And perhaps they don't want their kids to get a hold of this stuff for whatever reason. They want it to go to the trust the way William Saroyan wanted it. Well, you can do that for them, but to get it to that organization, you can't just put it in a trust. You got to do it through a will. And that, for those of you who practice trusts and estates law, that is probably one of the most important points I want you to walk away with today. The other scenario is then, okay, I'm disposing of my property. How do I deal with this? And I want to sort of create the right testamentary documents to deal with this situation. How do I do it? And so what I have on the next slide here is a general assignment. I didn't draft it, but it was given to me, and I was allowed to use it by a lawyer who deals with trust and estates work for folks in Hollywood and Beverly Hills, celebrities and the like. And so I certainly myself trust the document. This is the general assignment that he generally uses to make sure that copyrights pass through the will in a manner that satisfies the federal code if that is what your client wants to do. And so that is a good example. There are obviously others. You can get on Westlaw and you'll find others, of course. So we now get to you've learned all this, you're thinking about it, you're trying to figure out, for my existing clients, for the client who comes, for his appointment tomorrow morning, who are these people, and what kind of clients should I be thinking about these issues for as a general practitioner or as a trust and estates lawyer? Well, anyone who is in any way connected to the entertainment industry, artists, writers, painters, sculptors, glassblowers, audiovisual creators, musicians, songwriters, architects, even engineers. Engineers, you say, how could that possibly be the case? Engineers often write software and source code. And lo and behold, we had a case involving the heirs of someone who created some software in the 1960s. And they came to speak to us. They'd learned about our practice and how we help people in this area. And your first thought is, how could there possibly be any software created in the 1960s that has any value in the 21st century, right? I mean, software goes obsolete in a few years. It's hard to imagine. That was our first reaction. Right? Well, turns out this software happened to be software that, is used by the government and NASA for heat reentry, for, space shuttles and rockets that leave the Earth's orbit and come back. And it turns out that the way they deal with heat shield reentry and whatnot hasn't changed all that much in the years. And so needless to say, that was an example of folks who had, parent who had created some software that copyright inheres in, which may still be used today and have great value. So you never know who these people may be. And I can't talk more about that case because it's confidential, but I'm certainly glad they came and spoke to us. So sample questions. You have your checklists for your sort of intake for meeting new clients and just trying to get to the bottom of what they need you for, what you can do to help them. I've prepared some sample questions for you, and you can see them here on the slide. Have you ever created a work that you've assigned? I mean, it's a very, very basic question. It's not one you'd normally think about. Have you ever assigned a copyright specifically to someone, or perhaps some of the rights of copyright, that bundle of sticks, to someone? And if so, when? Was your parent or your spouse or your grandparent even someone who is in that list of industries I just gave you, who was a content creator that may have done something and created something and given it away? And you may have clients who have a lot of money today because dad or grandpa had created something and made a lot of money on it, and so they're living great and they've got money and they're doing planning with you for how to protect their assets and whatnot. But they may be able to augment their assets by going back and getting that copyright. And of course, if you're dealing with an estate and you're dealing with trusts and for obvious tax reasons, but you also have copyrights, you need to be cognizant of the will exception. So, in conclusion, these are sort of the points I really want you to leave with. Previously assigned copyrights can be recovered by authors or heirs. It's counterintuitive. Again, I can't stress it enough. Recognize that the federal law is simply different to everything you've ever known and expected under state law in the context of copyrights. Transferring copyrights through trusts is not a protected, guaranteed way of affecting the intent of the person who wants to do it. And of course, copyrighted works are valuable assets, and they exist in all areas of the economy. They can be worth large sums of monies to your clients and their heirs. And so you need to be watching for copyright issues, both on the estate asset side and on the transfer side. And so stay tuned for Superman 2. Thank you.